Hi everybody, welcome back. We are now on to defense attorneys this week, on to Module 6. In case you haven't seen, we don't have a whole lot of readings and a whole lot going on this semester. Not this semester, this module. And that's because we had a pretty good heavy amount of reading on prosecutors last week. And so we're going to have a little light week this week. I do want one quick reminder though. Remember that after next week is going to be our last module before the midterm. So we're going to talk about judges next week, and I think jurors too. Judges and jurors next week. There's going to be a little bit more reading there, and then we're going to be on to the midterm next week. So the semester is moving right along, and please make sure that you are remembering to do your quizzes every module and your discussion boards. And please don't forget to reply to another student. If you don't do that, then that takes away from your grade there, and that's an easy way to boost your grade. So if you're not doing that, you're really losing out. So with that being said, we'll move on to talk about defense attorneys a little bit. For those of you that have already read the chapter, or at least somewhat familiar with what defense attorneys do, this is not going to be a lot of new information for you. So defense attorneys are basically people who represent the defendant, the person who's been charged with a crime in court. They can be either privately retained or publicly provided. In the case of being an indigent defendant, which is just a big word for being poor. And we'll talk about the criteria for that in a few slides down the road. Their specific functions, they interview the client, the police, any other witnesses, and they represent the client in the pretrial and the trial procedures, negotiate plea deals with the prosecutors, and then of course they also represent the client in court. They would cross-examine witnesses in court, raise objections to evidence being introduced, which might violate some of the rules of evidence, as well as present the defense's case in court, as well as represent the client during sentencing and other things like that as well. So there are many different things that they do, and it pretty much involves the defendant. The defense attorney, they are the representative of the defendant. So whenever the defendant is there, if they have an attorney, then their attorney will probably be there too, especially if it's a privately retained attorney. If it's publicly provided, there are some instances when they may or may not be there because of the right to counsel's attachment and how the public wants to be able to pay for these things. Your Sixth Amendment, in case you all don't know, is where your right to counsel comes from. And so originally this started off, and your book goes into some detail about this kind of the line of cases. But one of the things that it doesn't really do, which I wanted to clarify, is in Gideon versus Wainwright was where they really started to, this became a big issue. And there was other cases where, right to counsel applied in capital cases or in federal courts. But Gideon versus Wainwright was the first case where they said that this applied to federal and state trials. And the book doesn't really tell you this. It almost makes it sound like it applies to all defendants, but that's not true. Gideon versus Wainwright says that when you're charged with a felony offense, so you have to be charged with a felony. When you're charged with a felony, then you get the right to counsel. If you're charged with any kind of misdemeanor or traffic offense, something like that, that's not going to count towards that. And if you're poor or indigent and you're not charged with a felony after 1963, then you would not have a right to a court-appointed attorney. If you were charged in that little window between 1963 and 1972. Now, the change with that came with Arger Singer, I'm going to say Arger Singer, versus Hamlin. This extended that to say that we're not just going to apply this right to having counsel to federal case or to felony cases, but it's going to apply to misdemeanor cases when you have the possibility of receiving jail time. So, for instance, if you're charged with drunk driving, or in some states possession of marijuana, or things like that, driving on a suspended license, there's a host of misdemeanors where you can receive up to a year in jail. And so in these instances, after 1972, you would have a right to counsel, and even if you're indigent, then they would have to appoint counsel for you. One of the things that can actually happen, though, and I've seen this happen in courts before, is someone might be charged with driving on a suspended license or something like that, and the person might ask for a court-appointed lawyer, and this is an offense where you can actually face jail time if you get convicted. But what the judge can do is say, well, I'm gonna look at your record and see that you have no prior offenses, so even if you do get convicted, I'm not going to give you jail time. So essentially they're waiving jail time, and then by doing that, you don't face jail time anymore, and then you don't have your right to counsel either. So you can still hire one your own if you want to, but what they're saying there is then the courts will not appoint you an attorney. So this is something that I wanted to make sure that you guys got from this, is, it doesn't just apply to felony defendants, and it certainly doesn't apply to everybody. If you go to court for a speeding ticket or something like that, assuming you're not going, really, really fast, in which case it becomes something that you could get jail time for. But say you're going, 5, 10 miles over the speed limit, something like that, there's not going to be any possibility of getting jail time for that offense. Now, if you have a suspended license too, then that would be another offense. But so in instances like that, now obviously I say right to counsel, but that means a right, so that you would have to have counsel there, and if you can't afford one, then they have to appoint you one. But even if you go to court for a speeding ticket, you still have the choice, and you can still hire your own attorney and have them represent you if you so choose. So that's an interesting thing to think about too and keep in mind. So I talked about indigent people and people who are poor, lack the means to hire their own attorney. Well, if you're charged with murder or something like that, you should be able to have an attorney, and your poorness or indigency should not affect that. So there's different types of indigent counsel, and I want to talk about this a little bit too. There's what is known as a public defender, and so there's court-appointed attorneys, and then there's public defenders. Both of these are types of counsel that you can get from the court, but they work under two completely different models. And so in usually your larger metropolitan areas, you'll have something like a public defender's office. And this is an office of public defenders, very similar to the prosecution's office or the district attorney's office. So they're members of the court in an office, usually in the city or county in which the court is. And these people only work on these cases where they're appointed by the court. And so one of the issues with this is that they're very poorly funded because nobody wants their tax money to be going to defend indigent people. They think that, well, if poor people are going to commit crimes, they should hire their own lawyers. I don't want to pay for criminals' lawyers. And the other issue with these is that they tend to be very, very overworked. And so you have a whole lot of poor people because that are requesting indigent counsel, and because they have poor funding, they usually end up being very overworked because they don't have that many people working there. One of the other issues that comes up with public defenders' offices is because they're so overworked and because funding is so poor, they're also not paid very well. So then you end up with this issue too, that you usually don't have the most experienced attorneys working at the public defender's office. They're usually people that are right out of law school. They do not have a whole lot of experience, and this was probably the best job they could get out of law school, and so this is why they're here. Now that, coupled with the fact that they're not going to have a lot of time to spend on the case because they have such a great amount of caseload, creates some issues within these programs. Now, the other type of model, which you'll see, and this usually applies to more rural areas, areas that don't have a lot of cases coming through for indigent counsel, is they have something called assigned counsel. And what will happen in these areas is all the defense attorneys in that area can sign up to be considered to be assigned counsel by the court. And what will happen is you'll go to court and you might get assigned 10 cases. And you'll take these cases in addition to whatever cases that you've been privately hired to do. And you'll get paid a flat rate. It's usually not a whole lot. You get $500, maybe $1,000 from the court, and $1,000 is on the higher end, definitely, to represent this indigent person. And so when you're in one of these areas, you have the possibility of getting a pretty good attorney. You can get it because this is a private attorney who's just looking to pick up some extra money, probably because he's in the courthouse anyway all day, so it might as well be getting more clients, right? And so many people I've seen have actually gotten pretty good private attorneys through this type of program. And so, there's research out there that says that, there's not a whole lot of difference between getting a court-appointed lawyer versus getting your own private lawyer. And I think that a lot of the limitations of that is they don't really distinguish between these public defender programs and the court-appointed counsel, because I think that you're going to see two different effects of both of those. And then they have contract attorney systems. Your book talks about this a little bit. To be honest, I've never actually seen this in an actual court system. Usually you'll get paid on a case-by-case basis, but I'm sure it must be out there somewhere for your authors to have written about it. I've just never seen it. I haven't really ventured too far from the East Coast unless I've been traveling. So, but essentially, instead of just saying we're going to hire you on an as-needed base, like the assigned counsel is, the contract would say we're going to give you such amount of cases, so we're going to give you 10 cases, 20 cases, 50 cases, 100 cases, whatever, and we're going to give you this amount of money to handle these cases. So that assumes that you're going to have all of those cases, right? And actually, one of the things that we do have is we have in Cobb County, we actually have kind of a contract attorney who works for the municipal court. And I've forgotten his name. I want to say Donahue, maybe. But he just works on contract. But he doesn't say we're going to give you X amount of cases for X amount of money. He's just on contract to handle all of the city attorney's issues in the municipal court. So he still gets paid for each case. But he's still on contract. They don't hire anyone else to do it. So anyway, some other issues. How far does the Sixth Amendment extend? So when does your right when does your right to an attorney start? If this was a policing class, we would say it goes all the way back to, when you start being questioned when you're in custody, right? When they read you your Miranda rights and they start asking you questions, your right to an attorney starts then. But that's a policing issue, and we're talking about courts. So we'll talk about these things from a court perspective. And so one of the things that you're guaranteed, to have a Sixth Amendment right to an attorney during sentencing, obviously during the trial, during the initial appeals, and then, juvenile and mental health hearings. But one of the things that you're not guaranteed is during the lineup. So if the police conduct a lineup, or during booking procedures, or during grand jury and preliminary types of proceedings, subsequent appeals, things like that. And then I've already talked about misdemeanors with no jail time. During these issues, you're not guaranteed to have a lawyer if you're indigent. Now, of course, like I've said, there's nothing to prevent you from hiring your own attorney, but they're not going to necessarily appoint one and have them there, because for each of these issues, that's time that comes out of their budget of limited time and resources. So you might not be able to get an attorney during these times. So another issue when it comes to defense attorneys that has been raised, and I believe your book talks about this, and I think Strickland versus Washington, if I'm not correct, if I'm not mistaken. Let me think here. Yes, Strickland versus Washington. I was right. Look at that. So it looks at whether your counsel was competent. And so this is an issue that has been raised, and the courts have really stamped down a lot on this, and it's very, very hard to prove that your counsel is ineffective. There have been cases where the defense attorney has actually literally been sleeping at the counsel table, and the Supreme Court has ruled that that was not an effective counsel because they weren't sleeping during the important parts of the trial. So trying to prove that you had ineffective counsel is almost impossible. It has happened in a few very limited cases. And so, if you think about this, if you have someone that's fresh out of law school and they're trying a murder case, then yeah, you probably don't have the most effective counsel. But they're not going to overturn that because of that. Now, then again, this is an ethical issue for the attorney. Someone with no experience should not be trying a murder trial when they're fresh out of law school, but that's not something that's going to get you out of your conviction. It's just something that's going to get them into trouble with the Bar Association. And so, like I've said before, one of the arguments is that criminal defendants are represented by public defenders don't fare worse than those represented by private counsel. I think that, if we distinguish between the PDs, the public defenders, and the appointed private counsel, then I think we would find some effects there. No one has actually done this to date, so that's something that I might end up doing down the road, but we'll see. And so these are all things for you all to think about, and certainly read through the chapter, and those 7 pages that you all had to read this module. So please do that and think about these things. And your discussion board is kind of to think about defense attorneys and how they might be seen as not being the best, or kind of looked down, because they do defend guilty people. And so one of the issues to think about is, just because someone's committed a crime, does this violate fundamental fairness? If we were to say, no, you don't get to have a lawyer, you were a rapist or a murderer. I think that one of the issues that goes to the core of our criminal justice system is we say, no, these people might have committed this heinous crime, they may or may not have, but it undermines the legitimacy of our system and the fundamental fairness if we decide to say, no, well, you're charged with raping a child, so therefore you don't get to have a lawyer, we're presuming you to be guilty, and we're not paying for you to have a lawyer even if you are indigent. And the vast majority of criminals cannot afford their own lawyers unless they're O.J. Simpson or, a big-time, drug dealer or something like that. So these are all things to think about. Your average street criminal is probably some sort of drug addict who's stealing things to support his drug habit, so he probably doesn't have a lot of resources to be able to hire his own attorney, and is probably going to end up with one of these public defenders and things like that. And remember, we talked about the courtroom work group and how the judge and the prosecutor and the defense attorney are all part of this work group. And so, the defense attorney makes up 1/3 of that courtroom work group, as I said before. So that was about all I had to say about defense attorneys. Please do be sure to read your 7 pages as they go into a little bit more detail about defense attorneys and things like that. And I will look forward to talking with you all next week. And as always, please let me know if you have any questions or anything like that. And with that, I wish you all a good week, and talk to you next time.